19 of the learned additional district and sessions judge, North and Middle Andaman, Mayabandar. Stop. The petitioner is a poor person and he is being represented by the learned counsel appointed by the State Legal Services Authority. No, you can hear the authority. You can stop. Whereas the learned counsel for the state or administration, what is state opposes the prayer for bail. According to him, the convict committed the offense against a child of 7 years of age at the relevant point of time, and if he is enlarged on bail, there is every chance of his absconding. Stop. Para. I have considered the materials on record. It is true that the petitioner has been convicted of the offense punishable under Section 10 of POCSO Act, and he has already served out maximum portion of his imprisonment of 5 years. Stop. It is also true that there is no chance of an early conclusion of the trial of the relevant appeal, and there is no chance that what you have said it.
We also prove that there is no chance of early conclusion of the trial.
Within trial within 4 or 5 months. Yes. Within 4 or 5 months. Stop. Stop. Considering all the aspects of the matter, I am inclined to allow the prayer for bail of the petitioner on certain conditions. Stop. The petitioner Biplab Pal may find bail of rupees. What is that? What would be the amount?
He is in 2000.
2000.
Because he is in jail, my lord.
Yes.
That is the difficulties.
5,000.
But personal bond may be given.
Personal bond. Yes. Convict.
Because
with
yes.
And that is law. Rupees 3,000 with one registered security of the like amount, and also on condition that he shall appear before the hearing of the before the honorable court for hearing of the bail application on each and every day, and further he shall meet the SHO PS Rangar once in every week.
Once in every week is very difficult, because when he was come here.
Rangat PS.
Yes, Rangat PS, but
Rangat
when.
PS is within his local jurisdiction.
No. My lord, from there, near about 100 kilometers distance from this place. Yes, that is the difficulties. Once.
No, there is no outpost of any.
He is a resident of Rangat.
Rangat, yes.
So PS Rangat is there.
Then
But every week very difficult, because when he will come here for hearing every day, That is difficult for attending
Every
there.
day, not every day, every day of hearing of the appeal,
Yes, my lord.
not every day
Yes.
to meet his counsel.
Yes, my,
Ah,
yes, my.
to appear before the court when the matter will be fixed for hearing.
Okay, no problem.
Okay,
Okay, no problem.
we are giving sufficient opportunities. To meet Judge Ranghat PS each and every day and shall not leave his residence at Rangat without permission of this court,
Yes, my lord.
of the learned, which will be the- without permission of
Permission from the special judge Mayavandar, from where the judgment was passed.
from the learned additional district and sessions judge. যেটা ওই আমরা যে অর্ডারটা যিনি দিয়েছেন কি হবে? Additional sessions judge come
No, for,
special judge under POCSO Act
at my lord.
N and M Andaman Mayabandar. ঠিক আছে? Now, the order of sentence is suspended until further order. And anything else?
Highly obliged.
Stop.
Hmm?
এই CRA 5টাও দিয়ে দিন বুঝছেন এখন এর সঙ্গে কি বলছে? Yes.
Regarding bail order, maybe comparable to the CGM Mayavandar, so bail bond can be submitted.
Let a copy of this order sheet be sent to the learned Chief Judicial Magistrate
Chief Judicial Magistrate Mayavandar.
Mayabandar for his information and necessary action. আচ্ছা ওখানে না ওই যে ওখানে একটা বেল বন্ড বললাম, বেল বন্ড 3000 rupees like amount subject to the satisfaction of learned CGM Mayabandar. Learned CGM Mayabandar এই কথাটা লিখতে হবে, ঠিক আছে? And this CRA, not CRM, this CRM SB CRM SB 1 of 2009 disposed of. Okay,
Yes, my lord.
anything else?
No, and another matter also, given the direction for paper book. Item number 5,
Yes.
correlated.
But
Because
don't do this type of
No, no.
offense once again.
no, no, no. No,
It's here CRA 5. I've taken call 5. One of two, এটা কি বিপ্লব পাল? Yes, one CRAN application is there. That is the section 5 that has been disposed of.
dispose of.
Now, এটা লিখে নিন তো। So, the learned, oh sorry, চলে এসেছে, দিয়ে গেছে না? না SB 2টা চলে এসেছে না, এটা চলে এলো সিঙ্গেল বেঞ্চ হবে বলে যে অর্ডারটা হলো
হ্যাঁ, দুটোই বলে দিচ্ছি, বলে দিচ্ছি।
পরে to SB for admission. CRM SB 1টা ডিসপোজাল হয়ে গেল, বেল অ্যাপ্লিকেশন ডিসপোজাল হয়ে বলে দিয়েছে এটা CRA প্লিজ as per direction of the court, as per order dated March 10, 2025, comma the learned counsel for the state has submitted the report received from the superintendent correctional home with regard to the period of custody of the petitioner. Stop. Let it be taken on record. Stop. It appears from the record. It appears from the said report that the petitioner oblique convict has already undergone 4 years. Almost 4 years, 4 months.
Yes, my lord.
So. So you have to file an affidavit in opposition or anything else?
CRA.
CRA?
No. Maybe fix for paperwork direction, LCR may be called
Call for,
for hearing of the.
yes, my lord.
The convict has already filed a bail application. Stop. The order of the judgment and order of sentence remain suspended until further order. Stop. Para. The petitioner is directed to prepare informal paper books when the matter will be next circuit.
Yes, yes, next subject.
Stop. This the matter. This the matter.
My lord, next circuit is not possible because lower court record will come from Mayabandar. So more time is required.
June, during the month of June.
Yes, yes, that will do. That will do. That will
Mr.
do.
Sarkar, you are a
Yes.
senior advocate.
Yes, yes.
Circuit bench, okay. কি বললাম, please place the matter before the next available circuit.
LCR may be called.
LCR will be called.
The trial court record, not LCR,
Yes.
ECR,
Lower court record may be called.
not lower court.
Yes.
Trial court.
Trial court record may be called for.
ঠিক আছে, ঠিক আছে।
High level.
Apply.
High level.
Yes.
How for the petitioner matter? I pay this matter one case for.
Who is for the other side?
Service is not in the.
Why service is not effected?
Day before yesterday, we got the CO number.
Before the trial court, I am holding the brief till now.
Okay.
I can accept the notice, provided a copy is
Yes.
given to me. I can come back next week. It's a matter of my bandha.
Yes, I am to here. What is the matter?
No, what they have claimed, actually, I don't know the color of the application. Really, I don't know. Suit is pending before the Maya Bandha, that's I know I'm the plaintiff there.
So the learned counsel for the respondent who appeared. Yes. The learned counsel, Mr. Joypal, learned counsel who appeared.
ये हम इसमें नहीं.
Who appeared before the learned trial court on behalf of the respondent oblique the plaintiff has submitted before this court that on instruction you will accept the notice of this civil divisional application.
Yes.
Civil division application if he is permitted to do so. Stop. Serve a notice. Serve a notice of
Yes, sir.
the petitioner's counsel is requested to serve the notice. Serve the notice or copy of
Copy of the applications along with annexes.
serve the copy of
Everything.
the application along with annexes to Mr. Joypal. Stop. When will come back?
Monday.
Monday. This is the matter of. Sorry, point.
In this matter also, my lord, how for the petitioner and service has not been applicable.
So, Mr. Joypal,
No, this is some other suit. I'm no one knows. No way connected.
the learned counsel for the petitioner has submitted that service is incomplete. So when he will come back?
10th of April, my lord. This is also the matter of Maya on the matter.
Yes, further submitted that he will serve the notices upon the opposite parties and come back with proper instruction on 10th April 2025. List the matter on that day. Okay. 10. Thank you. What thank you? No thank you to court. There are some yes.
My lord, I remember for its criminal revision application, my lord, I'm preparing for the petition. There will be a question of law, my lord, and even a plan is also filed, my lord, for 2 days.
What is the other side?
Other than, my lord, I have to serve as since it's a criminal revision.
So why you have not served?
Without the direction of the court.
Without direction of the court, you cannot serve.
Yes.
The learned counsel for the petitioner has submitted that service of the notices is required to be made in respect of the respondents hearing. Respondent. Sole respondent. Sure. The petitioner is directed to serve the notices as prayed for and to come back before this when? Monday,
Thursday, my lord, because the address here is at mainland,
Thursday,
Chennai, my lord, Thursday.
So,
Tamil Nadu.
Thursday. Well,
My lord, in this matter, my senior Miss G. Mini is appearing for the petitioner, my lord.
Item number?
6, my lord.
Item number 6. Yes.
My
No.
senior,
Your senior, who is your senior?
Miss G. Mini, my lord.
Yes. What happened?
My lord, this is a contempt matter, my lord. The order is passed by the Justice Uday Kumar, my lord.
So I have no jurisdiction. I have no.
It can be
authority.
placed before.
The learned counsel for the petitioner has submitted that the relevant order was passed by Honorable Justice Uday Kumar. Stop. So this bench has no jurisdiction now. So release. Register. Planner register. Planner register is requested to place the matter before the Honorable Judge in the principal bench. The matter may be released from the list of this bench. Okay.
Yesterday I was drawing my lords to the alleged will. Let me start with that. Few evidence, my lord.
And you have to show the judicial decisions.
My lord, absolutely. I'm equipped with those judgments. Absolutely. My lord, kindly turns to the very will at page 96 of the paper book.
Just a minute. Which page?
Page 96 of the paper book, my lord. Paper book.
Yes. Yes, 96.
So yesterday I was drawing attention of my
There is
lord.
no attestation.
Attestation is one part. As regards the date of execution, date of presentation, there is an anomaly. the trial court held it to be a minor slipshod. But I would say, Lordship, this created a suspicious circumstances that the will was never executed. I'll just place Lordship to page 96.
Yes. Will.
My lord, kindly turns to page 97 of this paper book. It's the second, that's the reverse side, rear side of the first page of the alleged will, 97.
Yeah.
My lord would see there are two seals at page 97. The first seal records that presented at dash AM PM on 24th of August 2005. My lord would find it at the first tabulation box. The presentation of the alleged date of will is 24th of August 2005. And my lord would see the signature of the registering authority at the bottom of the first box is 26/8/2005. And my lord now kindly turns to page 98 and 100. It's the second page of the alleged will. 98. My lord, got it? At the bottom, I have executed this will on this day of August 26, 2005. And my lord would find the same date, it's a handwritten, 26 has been inserted. My lord would find the same thing at page 100 also. By the scribe, Mr. Rajesh Kumar, being an advocate of this bar, was a scribe to this alleged will. 100. My lord would see, second paragraph, last line, Port Blair on this 26th August 2005.
Yes.
But my point of argument, which I have advanced before the trial court, was that if the will is alleged to have been executed on 26th August 2005, there is no scope to present it 2 days prior. And the trial court took it as if it's a mistake of the registering authority and it has been held that plaintiff cannot take benefit. Let's go with that situation, Lord. The evidence of the beneficiary needs to be seen, who is defendant. Her evidence needs to be seen. She has admitted in cross that there's an interpolation. Everything goes. I'll show that. Her evidence is at page 70.
7
My lord kindly turns to she is Malati Roy Chaudhary. She is the beneficiary of the will, based on which she got her name mutated in the land record. My lord turns to page 82, her cross-examination. Her cross-examination.
Yes.
And my lord would see fourth question from bottom. Page 82, fourth question from bottom. It starts with, is it true? Is it true that the date of registration of the said will was mentioned as 24/8/2005, but subsequently in the date mentioned below the signature of sub-register, it has been interpolated and written as 26/8/2005. She admits it and saying that yes. Now, it means there was a tampering with regard to the alleged will. If that be the case, the will is surrounded with suspicious. She of her own on oath before the trial court says that there is an interpolation. And how the trial court took it not as if it's a mistake of the registering authority. This can't be. No, I understand. If a man is at the deathbed, he wants to execute a testament, procedural technicalities is given a complete go by. The requirement of law is there. 2 attesting witnesses have to be there. And attestation is not a mere formality. I'll come to that. So my argument is the trial court's finding it that the registering authority have done some mistake.
This is a factual aspect, I think. No?
Not second appeal. I'm grateful. There are judgment of Supreme Court which says
If the factual aspects is not properly.
absolutely. There is a misconstruction of document.
Then-
There is a
then I
misapprehension of
can-
absolutely. The ultimate finding court is the appellate court. Ultimate. Even the appellate court missed it. I can raise it. So only substantial question has been framed in that regard.
What are the substances?
No, there are 2 in numbers. The substantial questions are 2 in numbers. I'll just, my lord would see the order dated 19th September 2023.
Page number.
No, it's an order sheet. No, it's
Oh,
the order
order
sheet.
sheet.
You're not finding the order sheet.
Oh,
Of
yes,
the,
yes. I have marked, I have tagged it
No,
for your convenience.
I'm grateful.
Okay.
I'm grateful. What would see?
Whether both the courts below are justified.
This will be sued by the appellant claiming declaration of right, title, and interest in respect of subject property solely on the ground that the moment the will is executed in respect of the said property by a person is found to be genuine, it creates a title into beneficiary / legatee of the said will. I'm on this question. These arguments are being advanced with reference to the material on record is with reference to the question number 1. Good.
And that secondly, what is that?
Whether a probate granted in respect of a will has any impact on the right and title and interest in respect of the property to which either the testator or the testatrix had fraction of title or no title thereof. Not our Supreme Court, presided over by His Lordship Honorable Justice Dipankar Dutta, recently have pronounced a judgment. I will place that judgment.
No, what is the?
But that means I have taken a ground in my memo that in these islands, though there are orders of this court which says that probate is not required, but the statute says probate is a must. Probate is a must. So any order in transgression to statute is judgment per incurrium. So only these questions came to be framed.
Till date, what is the convention here or something like?
Not.
Is there any judicial decision that probate is not required?
It's there. There are.
Division bench.
There are orders.
Because that there is no owner, only the government is.
No, that it was under the concept of section 57 and 213 of Indian Succession Act.
Okay.
So the division bench is said, but my point of argument is, but this Indian Succession Act, nowhere there is a restriction. But that's what I'm asking. I'm saying, arguing. If any order is passed by any court, be it by the Supreme Court also, Lordship, if it is contrary to the statute, can this court can go into those aspects? Not interpretation of.
If the division bench holds that a single bench
is binding.
cannot.
No, but the admission was done by the division bench. The admission of the second appeal was based on an admission by a coordinate bench. So the question, just 1 second, let me complete.
Yes.
Just 1 second. So my point of argument is what is running in my lord's mind, I can visualize it. My lord is asking you whether, as is already there's a division bench order staring, holding the field. Can this be decided? It can be done. Lord knows this come under the legal parlance, judgment in per incurrium. If any judgment is contrary to statute, it's obviously judgment in per incurrium. Even a lower inferior court cannot consider it, Lord. That's the point of argument. I will place those judgment. So, my lord, not this. Lord, again, I would say, yesterday I argued that the defendant have not used their additional written statement denying my plain case as regards the pair being made that the will is forced. Doctrine of non-traverse. Yes. Even then, I'm saying, there is no pleading of the defendant refuting my plain case that tantamounts to admission. What I have pleaded is admission. As I've been arguing, I am claiming right based on intestate succession. They claims based on testamentary succession. As a plaintiff, I have to show that my predecessor was holding the property. Upon his death, we have inherited it. There are evidence. Plain case, I proved it.
And your allegation is that he was not fit.
Well, these facts were absolutely not.
And he died after 3 years or something.
Absolutely not. This fact was pleaded in my amended plaint. There is no denial. That is the point. Evidence, I have said so in tune with plaint, amended plaint. There is no denial in the additional written statement. So what I have said about his condition not good at the time when the alleged will was executed has been admitted by the defendant, not. Even no suggestion was put to my client while cross-examining my witness. Am I clear, Lord?
There was a suggestion.
Suggestion, no, the legal
1A, 1B.
Legal value of such, there has to be concrete evidence that has to be coupled with a suggestion. Simplicity suggestion will not do, not. There has to be a concrete case, defense case to be made out. There has to be an evidence, then a suggestion. So my point of argument, because the defendant herself has admitted that there is an interpolation, and the trial court will not kindly see. But the trial court, may I draw my to that finding again, where the trial court held that it's a simple mistake
of
registry or for which the plaintiff cannot take benefit.
Registry person.
The defendant admitted, my lord, there is an interpolation. That goes to show that will is under a cloud of suspicious. If that be the case, then the onus immediately shift upon the defendant to prove it was executed validly, it was attested, due execution was done. Now, two witnesses were examined by the defendants. Two witnesses were examined by the defendants. They claims to be the attesting witness to the alleged will. I'll draw most of their evidence. The evidence of DW2 at page 86. Amal Sutar.
'86, yes.
86. And I will show my lord Amal Sutar's chief at page 84. 84 and 85 may kindly be seen. My lord, from the entire body of the alleged will, and if my lord reads between the line of the alleged will, my lord, there is no attestation. My lord, attestation is not an empty formality. My lord, what is the requirement of attestation? TP Act defines. I'll show that. What my understanding goes, my lordship, if his will is executed, then one of the witness, either in the body of the will, have to certify. He has to, it's called animus attestendi, that I have seen the testator expressing his desire to execute this testamentary document. After understanding, he put its signature as per his instruction. He signed it, I signed it, then the second witness signed it. Where is that in the alleged will, my lord? Where is that in the evidence? So there is no defense raised by the defendant as against the amended plaint about the nullity of the will. Even my lord would see 84. What 84 says, my lordship, I'll just paragraph 3. I'll read paragraph 3. Now kindly see, if my lord reads paragraph 3 of PW2, DW2, then this is hid by the evidence of DW1. Because DW1, my lord, again I am saying, I've just referred to DW1, the beneficiary will be, she said, it's 24th August. She said, it's 24th August. What DW2 says, on 26th August, page 84, last page, that on 26th day of August 2005, Sri Tarapada Chaudhary executed a will in respect of his landed property bearing survey number situated in Krishnanagar, Havelock, and the cell which was prepared by landed advocate Rakesh Kumar in his chamber, and thereafter read over and explained him that after understanding the contents of the will, I signed out the said will as an attesting witness. I can identify the will and my signatures and photographs affixed therein. But this evidence, so far as paragraph 3 is concerned, if my lord reads this evidence with DW1, DW1 said it's 24th August. If she has admitted it to be 24th August, his evidence to the extent of 26 as goes. It's a mutually destructive, lord. These two evidence, DW1 is the competent witness so far as alleged because she is the beneficiary. She said there is an interpolation. Matter ends there, lord. So there is no defense being raised. Everything goes. This Amal Sutar says that on 26th August, it's self-destructive evidence, lordship, of DW2. And my lord, kindly see this 84, this evidence of DW2. There is no whisper that this will was signed by Tarapada Roy in his presence, in a fit state of mind, in presence of the other witness, Kanan Bishwas. He signed, Baker signed first, we signed it second, the third witness signed it. Where are these evidence? Chief, it's nothing, simply execution. No, it's the execution saying will not do, Lord. I have got a judgment again of the Supreme Court which says will registered hardly matters, no value. One has to prove the will accordingly in terms of section 63 of C of Indian Succession Act. I'll refer to that along with 68 of Evidence Act. Lord, next, the second witnesses who came before the court, trial court as DW3 is one Mr. Kanan Bishwas. Lord, kindly see his evidence. Same thing. Page 88, his chief, he happened to be a parrot witness. Same thing. What DW2 said, same date, 26. Again, his evidence is contrary to the evidence of DW1. He has admitted it that there is an interpolation. 88, paragraph 3 may kindly be seen. Same. In cross, this DW3, I'll just show that. In cross, he said that he cannot tell what is written in the examination sheet, so it's no relevance, just I'm praising it. So my point of argument is not, neither the alleged will contain any recital as regards attestation. There is no not prescribed format. I'll read the TP Act once, not just kindly have a look to this definition of attestation. TP Act. There is no specified, there is no prescribed format, but this must find place in the alleged will. At least not in the will, in the evidence. It's lacking in the present case. I'll just show you. Not section 3 of the Transfer of Property Act under definition clause.
Hey, TP Act আছে? What is the TP Act? Please read. No problem.
It's 3 attested. Attested in relation to an instrument means and shall be deemed always to mean attested by 2 or more witnesses, each of whom has seen the executant sign or affix his mark to the instrument, or has been seen some other person sign the instrument in the presence and by the direction of the executant, or has received from the executant a personal knowledge of his signature or mark or the signature of such other person, and each of whom has signed the instrument in presence of the executant. But it shall not be necessary that more than one of such witnesses shall have been present at the same, and no particular form of attestation shall be necessary. No form is required. I do agree. But this requirement must find place in the alleged will, not that he saw the person, the maker of the will, expressing his intention to bequeath the suit land to defendant, excluding the plaintiffs being the legal heirs. He, a maker signed it, this witness signed it, the other witness signed it. This is a sine qua non, my lord. Now, what has fallen from my lord yesterday, I'm absolutely right. Had it been other instruments, sale deed, conveyance deed, I can understand. But will not, the maker will not be alive. I understand. The maker will not be alive when the will would come into force. The proving and disproving of those will would be live with these 2 witnesses. But there has to be the requirement, fulfillment of requirement, particularly when in the present case, my lord. Lord, particularly in the present case, when there is no challenge, whether there is no denial to my plain case as regards the nullity of the will, particularly when the defendant being the beneficiary of will in cross admitted, there is an interpolation. Matter ends there.
Okay.
My lord. Again, my lord, the scribe, the advocate of this bar, I'll just show his evidence, a very typical evidence, my lord. Paper book 92.
DW4.
DW4, Mr. Rajesh Kumar, at page 92 of the paper book.
Yes.
Well, I could see at page 92, the first question was, what is this document? Exhibit A is shown to the witness. This is the will prepared by me in my office on 26/8/2005. I'm pausing here. Again, his evidence has no relevancy in view of the evidence of DW1, who in cross-examination have admitted it's 24/6. She has said in cross, everything was done on 24/6. So the presentation was made on 24/6. Then how he could say that it was prepared, because the bill says 26/8. And it's in handwritten. There's an interpolation fully. Second question, do you know Kannan Bishwas and Amal Sutar? These 2 attesting witnesses, a question was put to this witness. I know Amal Sutar, but I don't know Kannan Bishwas. This scribe says, I don't know the second witnesses. He denies it. Now, cross-examination at the bottom, third question may kindly be seen. Have you prepared this document on 26/8/2005? He says yes. So kindly equate this, his evidence with DW. I'm concerned with that. The evidence of DW2, 3 and 4 have to be considered in the light of the evidence of DW1, because DW1 happens to be the competent witness, because she is the beneficiary. She said in cross-exam it's 24. It's a 24/8/2005. not 26. Everything goes. Will contains date as 26/8. There is an interpolation, defendants admit it. These things was not gone into in a proper perspective by the trial court. That's my argument, Lord. That is my point of argument. Lord, the trial court acted as an expert. Even I have brought the judgment of Supreme Court as well. I'll take one of that part. At the time when the comparison of signature of the maker was considered by the trial court, I'll show the trial court judgment and finding at page 132.
One
132, I'll just show. Lord, page 146, serial number 4, the finding of the trial court so far as the signature of maker is concerned over the alleged
130,
146.
146.
I'm just placing paragraph 4, Lord.
Yes.
DW1 stated in the witness box that she is acquainted with the signature of her father, testator, and she identified her father's signature in the witness box. And the signature of the testator on the will have been marked as exhibit A1, A2, A3. The learned advocate for the plaintiff pointed out the difference in the writing style of Tarapada Roy in the impugned bill. But on, it's a finding of the court, kindly see. But on perusal of the impugned bill, it appears that basic style of signing in each page of the testator is same. The identity card of the Tarapada Roy exhibit 1 collectively also recorded that the signature of Tarapada Roy, and this court compared those signature of Tarapada Roy appearing in exhibit 1 with the signature of Tarapada Roy appearing in impugned will. And this court finds that the basic style of sign is same. The attesting witness have stated that in their opposition that it was read over and explained and they have signed it. And the recording of the will reveals that the attesting witness have signed in presence of the testator, and the testator also put his signature thereon in presence of witness. In view of the above, this court finds and holds that the Tarapada Roy signed the will being number so-and-so, exhibit A in favor of defendant. Now, I have brought, because once I complete this, one by one, I'll cite the judgment. On this adjudication, there is a judgment of Supreme Court says, now, court is an expert of expert. That's true. But in the present case, in the present given case, the Supreme Court said the court should not act as an expert. A caution was given by the Supreme Court to all the courts of this country. Here, the court acted as an expert, adjudged as if it was the signature of Tarapada Roy, which is highly deprecated by the Supreme Court. It can't be done. Particularly when challenge has been thrown by the, because it would not. By this finding, one party's right would be affected. So the court should have been cautioned. Rather, the comparison could have been resorted to. So much also, why the court took this pain? There are judgments are brought. The Supreme Court said,
Question documents department is here. Question
no,
documents.
it's not, it's Calcutta.
It's Calcutta.
GQD is Calcutta. GQD is Calcutta. Calcutta may be here. Newton may be here. Newton CFS will take that. Newton. So this is the trial court went wrong here. Then, Lord, the last point, Lord, with reference to question number 1. Lord, as I've just said, in the case of Ghanshyam, the Supreme Court said that will, power of attorney deeds are not a deed of title. No one can acquire right title, which is presided over by His Lordship Honorable Justice Dipan Pradha brought the judgment in Shyam's case. Here, the trial court, while dismissing my suit, though there is no counterclaim set up by the defendants, but the right title has been conferred to defendant based on the allegation. This can't be done. This can't be done, Lord. Not just I'm placing the judgment one after another. I'll go with this judgment first, Lordship. 2023, Volume 7, Supreme Court cases. I'm just giving a hard copy of the judgment.
2023,
Volume 7, Lord. Supreme Court cases 361. 361 in the case of Ghanshyam versus Yogendra Rathi
Hmm.
by Justice Dipankar Datta and Justice Pankaj Mitra. My paragraph 14 is the relevant paragraph. In connection with general power of attorney and the will, page Lord would find at paragraph 14. Fourth page.
Yes, in connection with,
With the general power of attorney and the will, co-executed the practice, if any, prevalent in any state, or the High Court recognizing these documents to be the document of title or documents conferring right in any immovable property, is in violation of statutory law. Any such practice or tradition prevalent would not override the specific provision of law which requires execution of document of title and transfer and its registration so as to confer right title in any immovable property of ₹100 in value. So my point of argument is, while conferring right title based on the alleged will, that the trial court exceeded the jurisdiction. Not. It could not have been done. It could not have been done. Issues could have been framed. But the standard of evidence while proving a will as compared to other instrument is more.
exceeded his jurisdiction
My lord.
or did not exercise jurisdiction vested on him.
No, because the right has been conferred. Right has been conferred to the defendant.
No, he should have sent the matter to the question document. That is
Absolutely,
the-
Chief,
that is your-
absolutely. The power is vested with the civil court to exercise so much, my lord.
No,
But as I've been saying, your lordship, and not
he did not exercise his jurisdiction vested under law. He could have sent this matter to the question.
absolutely,
document.
absolutely,
It is your submission.
absolutely. Particularly when a challenge has been thrown, there is no denial in the written statement. No, that's a but kindly not doctrine of non-traverse. No, it's not so simple. In a civil case, there has to be specific denial. There are series of not knows this judgment.
So according to he should have submitted additional written statement or
absolutely, provided this evidence which the trial court has considered must have been based on the pleadings in the written statement. But there is no additional written statement as regards my challenge to the will in the amended plain.
okay. Next one.
My lord, this is one more judgment, my lord. I'll just yes. Yes. I'm going just reverse, Lord. Lord, this is with regard to the court of the power of the court to act as an expert. It's case of reported in 2012,
2012.
volume 12, Supreme Court cases, Lord. 406. I would be handing out the hard copy, no? In the case of Ajay Kumar Parmar versus State of Rajasthan. I'm just placing the relevant paragraph, Lord. Evidence Act 1872, Section 47, 73, and 45. Comparison of handwriting and signatures. Power of an approach to be followed by a court. Held. Court can compare writing sample given in its present or admitted or proved to be writing of the persons concerned, and there is no legal bar on court for comparing handwriting or signature using its own eyes, and it can make its own observation there. If situation so demands, court can take upon itself the task of comparison of signatures without sending for expert report. Though expert reports could be fallible, but it cannot be brushed aside as useless. However, cautioned when court is comparing handwriting or signatures, it cannot become expert. It must refrain from playing role of expert, as an opinion of court may not be a conclusive. Therefore, the court should be slow and hesitant to base its finding only on comparison made by it. So the finding of the trial court in the present given case that the signatures appearing in the alleged will of Tarapada Roy resembles with each other without resorting to the comparison, it's bad. This judgment I will place a hard copy, not
Para number.
para is not 24 to 30. Just one. No, it's paragraph 62, 64, 57, and 59 in the case of S.R. Srinivas and others versus S. Padmavatham, reported in 2010, Malord. Volume 5, Supreme Court cases 274. In the case of S.R. Srinivasa and others versus S. Padmavatham.
60,
Uh, 60, 62, 64, 57, and 59 are the paragraphs, relevant paragraphs. Will, proof of execution, suspicious circumstances, liability of propounder to dispel, where execution will was shrouded by suspicious circumstances, hence it was necessary for the propounder of the will to explain the same. Mere registration of will, not by itself sufficient to remove the suspicious. Finding of existence of suspicious circumstances recorded by the first appellate court on the basis of document which ought not to be brushed aside by the High Court as conjecture. It was rather the duty of the High Court to carefully examine said findings together with the relevant documents on record to ensure that there is a proper explanation by the propounder of such suspicious circumstances. That's lacking. Now, the alleged will has an endorsement of a registration authority that ipso facto would not be deemed not sure that this was duly executed by Tarapatha. On that point, this judgment of the law. I'm just not multiplying a lot. These judgments are on everything on different points which I've argued. Look, it's paragraph. This is the case of Anil Kak versus Kumar Sharada Raje and others. Anil Kak, reported in 2008, volume 7, Supreme Court cases 695. 2008, volume 7, Supreme Court cases 695. Anil Kak versus Kumari Sharada Raje and others by Justice S.B. Sinha and Justice B.S. Silpurkar. Here, what the ratio was laid down. If over a will, a legal heirs are excluded, which is in the present case, leaving the legal heirs, they were not given an inch of property, then the will would be under the cloud of suspicious. On this ratio, this judgment was pronounced, Lordship. The paragraph is, I'll just refer to the paragraph. Paragraph is, Lordship, 42, 43, 30, 40, 35, 42, and 43.
38, 42, and
45. No, it does not lie in my mouth to say that these judgments are cited. No, these judgments, not all are adulterated. The old one, which I brought right from 1977, on the point of it. But these judgments, I can see, Lordship, I do not say that, Lordship.
yeah, you should not say.
I absolutely. No, I'm not saying that. What my point of argument is not. I'm bound by it. Under Article 152, it's a precedent. I do admit. But what I want to argue is the old judgments.
Old is gold.
Old is gold. Not absolutely gold. These judgments, landmark judgment, I'll just show. Celebrated one. Right from 1958, AIR 1959, SC 443 by 3 judges bench in the case of K. Venkataracharya Iyengar versus BN Timmajama and others. Again, I'm citing this judgment, AIR 1959, SC 443. I'm just placing that paragraph. What are the requirements? This one. Old is gold, no, absolutely. That's one thing. Just one thing. I've noted it somewhere, right? Really, it's not drawing my attention. It's on the point also that the exercise to be undertaken by the propounder when a will is questioned. Yes, sir. It's paragraph 30. I'm just phrasing it, no?
Yes.
In the case where the execution of will is shrouded in suspicious, its proof ceases to be simple. List between the plaintiff and defendant, when what generally is an adversary proceeding becomes in such case as a matter of court's conscience. And then the two questions which arise for consideration is whether the evidence led by the propounder of the will is such as to satisfy the conscience of the court that the will was duly executed by testator. It is impossible to reach such satisfaction unless the party which set up the will offers a cogent and convincing explanation of suspicious circumstances surrounding the making of the will. This proposition was subsequently followed in one of the case reported in 1977, Lord, volume 1, 1977, volume 1, Supreme Court cases, page 369. In the case of Jaswant Kaur versus Srimati Amrit Kaur. So, Lordship, so far as first question is concerned, Lord, 105 of CPC's scope, my Lord Snooze. If in course of argument of a second appeal, if the Honorable Court finds that some more vital questions are required to be gone into, then this court can, based on the material on record, decide it. 105 of the CPC. Because admission has already been done by the revision bench. So my point of argument, these questions, rather these intricate questions of law, which was a basis of before the trial court, was not taken care of.
So what is your suggestion?
No, I would pray, because the first appellate court, well, I'm coming to the first appellate court, it's simpliciter judgment of affirmation. Now, under order 41, the first appellate court being the ultimate fact-finding court, because after trial court is the first appellate court who can reappreciate. High court can do it, but in a situation where there is a misdirection of evidence, misreading of evidence, misconception of document, under 100 it can be done. But I would pray for remand. It's my order 41, rule 23. I would
Trial court.
yes, but there is no evidence as of now, Lord. It's my humble prayer. It's my alternative prayer. My primary prayer is to allow the appeal, to set aside both the judgments, and to declare the suit.
And prayer for remand on which point?
Now, the points which I've argued just now, the point where there is no
The court acted as an expert. This should not be
doctrine
done.
of non-traverse was there. There is no denial to my plain case as regards
So
challenge.
then the trial court would again send the document to the question document.
No, Chief, it would be,
It is your suggestion.
it would be a limited remand. It can't be an open one. It can be limited remand under order 41.
Then how the differences in the date that can be solved?
No, it would remain. It would remain. That's exactly I'm saying. My first prayer is to allow the appeal, to satirize both the judgment and to declare suit. It's my prayer. Alternatively, I'm saying, Lord.
Why are you living with that testator at the relevant point of time?
My Lord.
You are the co-residents of the building.
Yes, yes. He happens to be my grandfather, plaintiff's grandfather. Testator had two daughters. My mother is one. Jayanti is one.
Yes.
She died.
Prior to the death of testator.
Yes, my Lord.
And the testator said that the defendant was looking after him.
It was, no, that's what I'm saying. If the bill is not executed, rather has not been made by Tarapad, everything goes, not.
So
It's
prayer for remand is your alternative.
prayer. My first and primary prayer would be, my Lordship, to allow the appeal to set aside both the judgments of trial court as well as first appellate court and to decree the suit. That's my prayer.
Okay.
That's all. That's all.
Yes, please, sir. So you have been asked to that no issues has been framed about the voidability of the, that is the first. No additional written statement has been filed. Reasons for exclusion of other years has not been mentioned in the relevant will, and the differences of dates. These are the main.
Everything is there in the judgment passed by the trial court as well as the first appeal court. My lord, here, the division bench of this honorable court framed two substantial question of law. So we are to confine ourselves to give answer to those substantial question of law.
Yeah.
The substantial question of law is that the law point involved in the suit, but it was not decided before the trial court as well as the first appeal court. Here the issue has already been decided. Now my learned brother, harping upon the point, there is the interpolation on the data. And that has been decided by the trial court as well as the first appellate court, and clearly decided. And that was not the issue involved in the substantial question of law framed by the division bench of this honorable court. My learned brother produced certain judgments, but what I can say, I have gone through those judgments. Those judgments will not help my learned brother to decide the appeal hearing, because whatever the issue to be decided here, my learned brother argued to some other points, some facts. My lord, this is not the first appellate court. First appellate court, my learned brother argued, marathon argument was done. And thereafter, the appeal, first appeal filed by the appellant hearing, that was decided, that was dismissed. That was dismissed, and the judgment passed by the learned trial court was affirmed. And my learned brother says that the signature, which was not matching, the court has to suo motu issue the document to the GQD for tally the judgment. But when the first appeal has been filed, my lord knows that there is a provision under Order 41/27 for additional bail. What restrained the appellant's hearing to file an application under Order 41/27 before the first appellate court? That this point has not been decided. So let the document will, as well as the signature, may be sent to the other documents, may be sent to the question document for tally. Here, the court has come to a conclusion. It is in the judgment passed by the learned trial court as well as the first appellate court, come to a conclusion. The signature appear in the will, as well as signature appear in the other documents of the testator. That was tallied. And there was no question arises. Even in the plaint I have gone through, that they have not stated anywhere, they have not challenged the signature appearing in the will. They are not saying that the signature which is appearing in the deed of will, that is not the signature of the testator Nirapadura. It was not under challenge. So why the court was so to send the matter to the GEQD for verifying the signature? It was not in the pleading. My learned brother argued yesterday that there was no issues framed in respect to the genuineness of the will. But here, if my lord says, look to the plaint filed by. Plaint has been filed. I have filed my written statement, and after going through the plaint and written statement, the court framed the issues. That point of time, there was no challenge in the deed of will. When I filed the copy of the deed of will along with my written statement, thereafter they have amended the plaint. And before that, the issue has already been framed. And when the plaint has been amended, they had to file an application before the learned trial court that these new things have come by way of amendment. So in this respect, the additional issue is required to be framed. No application has been filed. So there was no issue at all. So, and the will, my learned brother argued, my lord, can you come to the will? That is very, there was no attestation, nothing. Page number 96, so for I remember. Yes. Page number 96. I am reading the relevant portion, page number 98, last paragraph. I have executed this last will on this day of August 26, 2005 at Port Blair, and this will has been drafted by my advocate Rajesh Kumar on my instruction. And after the contents of this will were read over and explained by my said advocate in Hindi, and after duly understood and fully satisfied about the contents, I have in presence of the witnesses, both of whom were present and listening while this will was read over and explained by my said advocate, and they have also signed this will in presence of each of them. Now, signed by the named testator, this is the attestation point. Testator as his last will and testament in our presence, all being present at the same time. Thereafter, at his request and at his presence and in presence of the other, we subscribe our respective names in the chamber at the chamber of Advocate Rajesh Kumar Podlar on such and such date. So, what more required for attestation? And these two witnesses, Amar Sutar and Kanon Bishal, both of them have been examined. And they have admitted their signature, they have admitted the signature on the will, that this is my signature, it has been drafted by learned advocate. After going through the contents, I put my signature, they are attesting. I am coming straight away by the evidence of that, those witnesses, which is at page number 84. Very small because he is only the attesting witness of the will. 84. The evidence of one of the attesting witness, Kamal Sutar, being the DW2. That I have received summon to witness from this court to depose. He has been summoned by the court. I know Sri Tarapada Roy, who is the testator, Tarapada Roy Chaudhary, and his daughter Srimati Malti Roy Chaudhary from my childhood. That on 26th day of August 2005, Sri Tarapada Roy Chaudhary executed a will in respect of his land bearing survey number such and such, hectare situated at Krishnanagar, Havelock, number 6. The said will was prepared by learned advocate Sri Rajesh Kumar in his chamber, and thereafter read over and explained in Hindi. That after understanding the contents of the said will, I signed over the said will as its attesting. I can identify the will as my signature and photograph affixed therein with the said will. So it's identified and it has been exhibited, signature has been exhibited. And next witness, the similar witness, Kanon Bishal. He also stated the same thing, that it was prepared in my presence, the testator was present, he put signature. I also put my signature in presence of the other attesting witness. So attestation is completed. What section 68 of the Indian Evidence Act says, that in respect to the will,
68 or 63?
68, so far as it was 68. In respect of will, the will can be proved by any one of the attesting witness. Here I called both the attesting witness, and both the attester admitted their signature as well as the existence of the will. Even the learned advocate who prepared the will, he also examined. He also admitted, yes, this will was prepared by me in my chamber at the instance of the testator, and he also put the signature. He has given the evidence. And the learned trial court as well as the first appellate court said, yes, the genuinity of the will has been proved. Genuinity of the will has been proved. Here the signature appearing on the will, that was not denied by the plaintiff's area. And my learned brother says both are in joint possession of the suit property. My lord, kindly see the address of the plaintiff in the cost title of the plaintiff as well as the memo of appeal. Somebody residing at Bilanipur, somebody residing at Dundas Point, somebody residing in some other places. But the addresses mentioned by the plaintiff, addresses of the respondents herein, the address of the suit property mentioned there. And what is the intention of the testator? My lord knows that in view of section 2 of the Transfer of Property Act, court should not see the technicality of a will because there is no prescribed format in the will. Court should see the intention of the testator. What was the intention of the testator? That he had two daughters. One is the predecessor of the plaintiff sharing, plaintiff appellant sharing, and other is the defendant respondent. So till the death of the testator, the defendant, respondent look after the testator. And that is the reason, and these plaintiffs or their predecessor never look after the testator. So that is the reason this property was bequeathed in favor of one of the daughter. And the daughter, that daughter is in occupation, and my land says that the title has been transferred. No, my lord, the documents are available in the paper book. I filed an application for mutation to the Tahsildar Court Blair on the basis of registered will. And notice has been issued. Notice under Form J under Rule 135 of
What is the regulation here? The
Regulate-
probate
probate is not mandatory.
why is that rule? I want to know for my
Yes.
curiosity.
Section 57 of the Indian Succession Act. Probate is not necessary. Even the judgment passed by the division bench of this, so far I remember Honorable Justice Alok Ganguly. 2005 judgment division bench passed.
Alok Chakraborty.
Alok Chakraborty. So that judgment, division bench judgment is there in the case of Kumud Ranjan Shaujal versus Srimati Bimala Kaur and others.
Ah.
In that judgment, the honorable division bench held that in these islands probate is not necessary. If you are having a registered or unregistered will, you have to, after death of the testator, you have to produce the will before the Tahsildar concerned for mutation of the land on the basis of the will,
Yes.
and prove the will before the Tahsildar. And the Tahsildar will accept the will as a documentary evidence.
So he will call the other heirs also. Tahsildar will
Yes,
issue notices.
yes. In this case also.
Okay.
This case also. Notice under Form J, that is under Rule 135 of the Rule 1960.
Can we produce that judgment?
Yes, tomorrow I can produce.
Okay.
It is reported in ILR also.
Oh, okay.
Yes.
Yes.
So honorable division bench held that the Tahsildar will take that will as a evidence. And if the Tahsildar found that it is a genuine will, after taking evidence of the attesting witnesses, he can mutate the land. And the objector who filed the objection, he can challenge the mutation before the trial court, before the civil court, that this will not. But Tahsildar has to mutate there if the Tahsildar is satisfied with the will. So I have produced the will. Form J notice has been issued. One occasion, the appellant herein appeared before the Tahsildar and he seek time to file written objection, but no written objection has been filed. Thereafter, several opportunity has been given. There are 5 newspaper publication also there asking the appellants herein to come forward, file their written objection. They never come. Subsequently, one learned advocate, Mr. K. Sabir, has been appointed by them to file written objection. But before written objection, they filed the suit and produced the same before the Tahsildar that we have already filed a suit challenging the claiming the right title, interest and share from the property. So now thing is that very vital question is there. When I applied for mutation of the suit property in my name on the basis of the registered deed of will, the plaintiffs herein must have known that I have applied for the mutation on the basis of will. At that point of time, they had to file the suit challenging the will, but they have not. After that, they filed a suit for claiming the right title, interest and share from the suit property. They have not challenged it.
Okay. So you have concluded. So everything has been no technicalities, only the intention of the testator.
Yes.
And now all these factual aspects, so that this court can go into these factual aspects right now.
No, only we have to confine ourselves to the substantial question of law framed by the division bench of this honorable court. What is the first substantial question of law? Whether both the courts below were justified in dismissing the suit filed by the appellant claiming declaration of right title and interest in respect of the subject property solely on the ground that the moment the will executed in respect of the said property by a person is found to be genuine, it creates a title into a beneficiary legatee of the said will. My submission is that even the title has not been created in my favor. When the suit filed, the Tahsildar passed an order. The matter has been adjourned sine die because the civil suit is pending. I am showing that relevant page of the revenue order sheet. Is that page number 113. First order I am reading. There are several orders. Received an application from Malti Raj Chaudhary, daughter of late Tarapod Roy, R.O. Krishnanagar, Hablok in mutation of the land bearing survey number such and such, situated at village Krishnanagar, Hablok, registered as a revenue case. The application in original was forwarded to Patwari circle number such and such, taking action under Rule 135(3) of the Anonymous Island Rule 1968 and make necessary entry in the mutation register and submit his report. Case taken up today. As per the report, the Patwari has issued notice in Form J to all the parties interested. That means the plaintiffs hearing also. In his proposed mutation, inviting claim objection, if any, making entry, duly making entry in the mutation register of village Krishnanagar on such and such, received claim objection from such and such stipulated period from the date of receipt of the notice by the parties. This sharp copy of Form J is also added. That means notice has been sharp to the plaintiff hearing. That was added. Issue summon to all the concerned, requesting them to appear before me in my court at 3 p.m. on 16/9 along with original copies of documents, etc. Now, case taken up today, Srimati Malti Raj Chaudhary and Sri Nirapado Chatterjee on behalf of his 5 children. That means 5 children is the plaintiff's hearing. Present, Srimati Malati Raj Chaudhary applied for the mutation of landed property being such and such, situated Krishnanagar village as per will executed by her deceased father Sri Tarapadurai. That means the plaintiff knows about the existence of the will before filing of the civil suit. Form J issued to all the concerned for submitting claim objection, if any. Sri Gopal Chatterjee, Molina Chakraborty, Sumitra, who are the plaintiffs? Sumitra Chakraborty, Sushuma Chakraborty, and Sabuni Chakraborty filed objection against the mutation entry in favor of Srimati Hatnan. Further state that they are in children of late Jayanti Chatterjee, daughter of Nirapudora. They are also the legal heirs of the recorded tenant, case adjourned for further inquiry. It appears from the, but they say we will file objection, but no, there is no objection filed by them. It appears from the proceeding dated such and such that the Nirapado Chatterjee on behalf of the children was present and had filed objection. However, records does not reveal that any objection has been filed. Moreover, no stakeholder except the applicant has been appearing. It could be just to afford all of them an opportunity of being heard before proceeding any further. Notice is the last chance. Case next case filed up before me with reference to order dated such and such, a notice was furnished in the Daily Telegraph, published in the Daily Telegraph dated 9/5/2009, 11/5/2009, 18/7/2009, and 19/7/2009, calling upon all the interested parties to attend the court on 28/7/2009, but none of them appeared. Today, learned advocate Sri Sudarshan Bisha, counsel for the petitioner, that means my counsel, Malati Raj Chaudhary, present. As per documents on record, Advocate K. Sabir on behalf of objector filed wakalatnama. Since none of the objector appeared personally, a last chance may be given for which a final publication in the Daily Telegraph may be given. Case came up for hearing on such and such. Learned counsel for both parties present, learned counsel Sabir submit that there exists a civil case for title. So before file, no objection has not been filed before the Tahsildar, but filed the civil suit, even having knowledge that I applied for mutation on the basis of registered will, that will has not been challenged. Filed a suit for declaration of title and share of 1/6 share. Thereafter, last order may be seen, and page number 119, 120. These are the newspaper publication claiming it objection.
Now, if the civil proceeding is filed, then Tahsildar will not take any.
Yes, that has been done.
That is the.
That has been done. Yes, that has been done. Last order may be seen. My learned brother says that the title has been created in my favor. I am showing that document. Page number 119. In the previous hearing, learned advocate K. Sabir has produced an extract of TS number 82 of 2009 and Gopal Chatterjee versus Srimati Malti Rai Chaudhary, and in respect of survey number such and such situated at Krishnanagar for declaration of title, interest and partition. Hence, status quo is to be maintained. Case is adjourned sine die. As because this matter sub judice before the learned civil court. So Tahsildar adjourned the matter sine die until the decision, final decision.
Mutation was
not proceeded further. Until there is a law, until there is a civil suit pending, until the suit is decided finally, the Tahsildar will not proceed further. So the first substantial question of law, there is no title created. Now, second, whether a probate, that has been answered properly, that there is a judgment passed by this division bench of this honorable court, the probate is not mandatory.
probate is not
Not mandatory in this act.
mandatory.
Mandatory. My learned brother argued very well, but beyond the substantial question of law framed by the division bench of this honorable. Here, after admission of the second appeal, my learned brother also filed a CAN application for stay of the judgment and decree passed by the first appellate court as well as the learned trial court. And that stay application has been dismissed by the division bench. That no, you don't have any right title interest over the sold property, so stay has not been granted by order dated 13/10/2023. The CAN application has been dismissed. 13/10/2023, the stay application has been dismissed by the division bench of this honorable. That is in the order sheet.
Yes.
Now, regarding the interpolation of the date, my learned friend harping upon that points only. Interpolation. While I am showing the one page of the judgment passed by the learned trial court, that is page number 144.
Yes.
Paragraph number 2. It was pointed out that the reverse side of the first page of the will recorded the date of the presentation of the will as 24/8/2005, whereas the execution was done on 26/8/2005, and in one place on the said page, the date 26/8/2006 was overwritten. But it is to be remembered that the reverse side of the first page of the registered document remained in the domain of the registry office. So I have presented the will. The manipulation or interpolation or wrong date has been mentioned the reverse side of the page. And neither the testator nor the attesting witness or the who prepared the will, they don't have any control over that page. We have presented that seal, sign, everything has been done in the registry office. If there is any wrong committed by the office of the sub-registrar, registry office, the testator or the beneficiary or the attesting witnesses should not suffer, should not be victimized for the wrong committed or mistake committed by the registry office. That has been done by the trial court.
Now, when the execution was taken place?
26. The 26 August.
So, and when it was presented?
Same day. Same day.
The reverse side it has been written as
The
20.
reverse side, that is the control of the sub-registrar. We don't have any control over
Then
them.
even it is, there is no interpolation in the first seal, there is a, till now, that has been recorded as 24/8/2005. Written, just come
Yes. Page number 96.
96, yes. 96.
Handwritten.
And written the first seal, that is the interpolation in the sub-registered seal, for 26/8/2005 or 6, whatever.
Fine.
But presented, this has not been changed or anything modified. Presented at such and such time, the 24th day of August 2005.
Page number 97, my lord.
97, sorry.
97. Page number 97, there is overwriting.
No, that is overwriting. That is the in the seal of the, just by the side of the seal of the.
Yes, presented at such and such the
No, no, and
24th
such
day of
and such,
August.
and
In the
and
seal. In the seal.
in the seal,
Yes.
square seal, presented, please, first line.
The 24th day of August 2025.
Yes, that is.
That has been written not by the testator, nor.
That I understand,
Yes.
but it remains the same. It has not been modified or changed or corrected.
That is the
whatever.
mistake committed by the office of the sub-registrar or the dealing staff.
And that is
What, yes,
that,
for that,
that was a issue.
beneficiary should not be victimized for that. Now, that has been decided by the learned trial.
That is a wrong till now.
Wrong, but it has not been decided. Now, as the execution was done such and in one place, it says the date 26/8/2000 was overwritten. But it is to be remembered that the reverse side of the first page of the registered document remained in the domain of the registry office, and entire reading of the reverse page reveals that there is fault on the part of the concerned registrar to put the date and to override the date 26/8/2005. On the same page, at the bottom, the registrar has given the
yes,
correction.
yes, we have gone through. And another thing is that he has acted as an expert. Why he has acted as an expert?
No,
Yeah, not here. In another portion of the
Judgment.
comparing the handwriting.
yes.
That you please deal with this point.
Page 146.
No, this is the observation of the learned trial court that the signature appear in the will as well as signature appearing in the other document of the testator. They are looking as similar. But if there is any question, even in the plain case of the plaintiff, they have not challenged the signature of the testator in the will. There is no question.
That ground should have been taken, but he has.
No, it is stated in the identity card of Tarapodorai. I am reading.
It is not correct.
4. Yes, 4. The DW stated in the witness box that is acquainted with the signature of her father, testator, and she identified father's signature in the witness box, and the signature of the testator on the will have been marked as exhibit such and such. The landed advocate for the plaintiff pointed out the difference in the writing style of Tarapada Roy in the impugned will. But on perusal of the impugned will, it appears that basic style of signing in each page by the testator is same. The basic style, not confirmed, basic style of the handwriting. And exhibit 1 collectively also recorded the signature of Tarapadar, and this court compares those signatures of the appearing. So we should not harping upon this argument here, because there is no substantial questionable framed with respect to this point.
Yes.
We should not enter into this point.
So we should not.
We can ignore this point because division bench of the
But if the factual aspect has not been correctly appreciated, then the second in the second, I think court can.
Can we come to the first?
Whatever it may be, I think you have completed all the points.
Only I would like to show the judgment passed by the first appellant.
Yes, yes.
Where the judgment passed by the trial court has been affirmed.
Yes.
The page number 171. Very small judgment.
Yes, yes. One 171.
170. I am reading from 174, decision with reasons.
Yes. No, he has maintained everything.
Yes. After going through this lower court judgment in connection with such and such, it appears that the learned court below was pleased to frame issue inter alia as to whether the plaintiffs, the appellants of the present appeal, have any right, title, and interest to the extent 1/6 share in the suit property, or they are entitled to get that decree or any other consequential relief as granted for. The learned court below has discussed in the judgment that Tarapodo Rai Chaudhary, the recorded owner of the suit property, executed a will being number such and such in favor of his daughter, and such there is no scope for the plaintiff to inherit the suit property on the death of said Tarapodo Rai Chaudhary. The learned court will, after through discussion, arrived at a decision that the will in question exhibit A has been properly executed and attested, and the same is genuine. and the same was also the last will of the testator. And said will has been properly proved by the profounder of the will and came to a conclusion that the will in question is genuine and the plaintiffs have no right to claim any right title interest in respect of the suit property in survey number 25 within such and such, that is situated at Krishnagar village, such and such. The decision of the landed court below since gone against the plaintiffs of the title suit number such and such, which was renumbered as such and such, they have challenged the impugned judgment and decree by preferring this appeal, pointing out the defects of the discussion made in the judgment in deciding the fact that the will in question is genuine. The appellants during course of their arguments stated inter alia that Tarapodora Chaudhary had no authority to execute a will in favor of his daughter Malti Rai Chaudhary since the property number such and such situated Krishnagar village, Ablok, under Postler Tehsil, South Andaman was allotted under constitution for the benefit of his family, which includes the grandmother and mother of the plaintiff, Tarapodora Chaudhary, by depriving the right title and interest over the suit property of his one daughter, executing a will in favor of his another daughter. That is the defendant of the title suit in question. The learned court below was erred in deciding that the will in question was genuine. Accordingly, they are praying for setting aside the impugned judgment and decree. As per the appellants, since the property in question had been allotted in the name of Tarapodora Chaudhary under covenant scheme for the benefit of his family, which includes his wife and daughters, and when the appellants are legal heir of one of the daughter of the Tarapodora Chaudhary, they should not be thrown away from their legal capacity, and when the learned court below was erred in deciding the will in question is genuine and depriving the plaintiff. They are praying for the setting aside the judgment of the substance side by side. It has been stated that the learned court below was erred in holding that the defendant ought to have duty to file counterclaim against the prayer of the plaintiff. Specifically, they have stated that the defendant of the suit, rather the respondent of the present appeal, when failed to file any counterclaim, the learned court below would have mentioned in the judgment but failed to appreciate it and arrived at a wrong decision. According to the appellants, when the defendant did not make any claim against the claim of the plaintiff, how the learned court below has arrived at a wrong decision that the will in question executed in favor of the defendant by her father, that the Tarapodora Chaudhary is genuine. It is beyond their imagination. It is their specific case that in the alleged will there is no mentioning about the family structure of the testator, and also not mentioning as to whether the legal heirs of the testator is alive or not. Since the will in question is doubtful and where the defendant did not make any counterclaim, where whatever decision taken by the learned court below was absolutely wrong, and that decision should be set aside. After going through the entire lower court record and also the decision taken by the learned joint civil judge senior division Port Blair in connection with title suit number such and such, which was renumbered as such and such, I find that the learned court below, in order to decide the suit, has been pleased to frame the following issues. There were issues. Then, perusing the entire judgment passed in connection with this suit number subsequent, it appears that learned court below has emphasized on one thing: the will in question, which was executed by the testator Tarapodora Chaudhary in favor of his daughter Srimati Malti Rai Chaudhary, the defendant of the said suit. Since the plaintiffs have claimed their right, title, and interest in the suit property, and also claim for partition and pay for 1/6 share in respect of survey number such and such, measuring such and such hectare, situated Krishnagar village, Hablok, under Postler Tehsil, South Andaman. The learned court has rightly discussed about the genuineness of the said will, including its execution, attestation, and also the circumstances for execution of the will, since the entire claim of the plaintiff is depending upon the said will. If the will in question is found to be a false will, and or the same has been executed without any proper manner, or the testator has no capacity to execute such will, or he has no capacity to understand the situation for which the said will was executed, in that situation an adverse interference could have taken by the learned court below. But since the learned court below was satisfied about the attestation, execution, and genuineness of the will, there was nothing left for the said court to decide the negative in respect of the issue relating to right, title, and interest of the plaintiff in respect of the suit property. In every civil suit, it is the solemn duty of the plaintiff to prove their case, but they should not stand upon the lacuna of the other side. Defendant here, in the instant case, plaintiffs have failed to prove their legal right, title, and interest of the suit property since the defendant by adducing the evidence has been able to prove that the will exhibited, which has been executed by Tarapada Roy Chaudhary in her favor was a genuine will and there was no collusion between the execution of the said will. The learned court below had no option to negate the prayer of the plaintiff. I think when the plaintiffs have realized that a will has been executed in favor of one of the beneficiaries of the property left by Tarapada Roy Chaudhary, they ought to have challenged the said will in proper manner. Here in the instant case, getting scope to contradict the said will, when the plaintiff have failed to prove that the will in question was not genuine, the inference regarding attestation, execution, and proving of the will in question by the learned court below cannot be said improper. Rather, I can say the decision taken by learned court below is absolutely correct, and I do not find any illegality in this respect. Since in a suit, both plaintiff and defendant has a right to adduce evidence, and when in instant suit the order to disprove the right of the plaintiff, the defendant has adduced evidence and able to prove that the will in question has been properly executed and attested, and the testator, after understanding the situation, executed will in favor of his daughter. Whatever decision has been taken by the learned court below in respect of execution and attestation of the will in my opinion, does not suffer any illegality, and accordingly, when the learned court below has arrived at a decision that the plaintiffs have failed to prove their case, I do not find any reason to interfere about such decision. Rather, I can say that the judgment passed in connection with the title suit number 30 is absolutely correct. And on the contrary, this court finds that the appellants have failed to prove their case. As a result, the appeal fails. Now, here, I have not challenged the genuinity of the will. The plaintiffs challenge the genuinity of the will, that it is a false or signature appeal is not. So the plaintiff has to prove their own case. My learned brother argued that when the plaint has been amended, I have not filed any additional written statement. What I will say in the additional written statement, no, it has been properly executed and registered in my favor. That will be the repetition of my defense case. I have already filed my written statement against the plaint filed by the original plaint filed by the plaintiff's hearing. I have stated everything. I have produced the document that there is an existing will in my favor. So if I file an additional written statement when the will has been challenged by filing an amended plaint, so that would be a repetition. If assuming for a moment that suit was proceeded ex parte, I was not the payer. Even in that case also, the plaintiff has to prove their own case. So here, the question of negating the points taken in that is not the admission. If it is gone ex parte. So that does not mean the defendant did not come forward filing written statement and denied the allegation made in the plaint. So it has been admitted by the defendant. The plaintiff has to prove the case.
That's all.
Yes.
So you have already mentioned all
Just
these
a law
law
point,
points.
just one line, I will not take, only a law point. 100, will not kindly have a look to 100, section 100, subsection 5 of the CPC. I'm just placing it.
100.
Section 100, subsection 5 of the Code of Civil Procedure.
Ah,
No, I'm just reading it. The appeal shall be heard on the questions so formulated, and the respondent shall at the hearing of the appeal be allowed to argue the case does not involve such question, provided that nothing in this subsection shall deem to take away or abridge the power of the court to hear for reasons to be recorded the appeal on any other substantial question of law or not formulated by it, if it is satisfied that case involves such question. My point is, Lordship, two questions are there. My brother is saying what I have argued is no way connected with those questions. I say it's connected. First question one is connected, one is connected. Even then, 105 gives this court a power based on material on record to allow us to argue the matter.
law points.
Well,
Yes, that's all. So I have the learned counsel for the appellant has resumed his submission and concluded and concluded his argument. Stop. Para. The learned counsel for the respondent. How many respondents are there? Only one. Has also concluded his submission. Stop. Judgment is reserved. List the matter. on 9th April for judgment or order there. Okay. And another matter, similar matter, second matter,
Both.
the same.
Yes, same.
So only one
Yes.
judgment or two judgments?
No. Appeal is one judgment, one decree. But appeals, second appeals has been preferred individually by two plaintiffs.
So two orders are must.
The questions are same.
No, arising out of same judgment and decision.
Yes. Same.
Two appellants filed separate second appeal.
So only
Same
one
question.
common judgment.
No common judgment.
Even in the second
Yeah,
appeal,
one
second one, same questions has been framed. by the
Same.
plaintiff. Same question.
Okay. So only one common judgment by.
Yes.
Two plaintiffs filed separate second appeal.
Yes.
I will provide the judgment.
Now, what is the name of that Kumud Ranjan or something like that?
Yes, I will provide the judgment passed by the division bench. Kumudaranjan Savjar versus Srimati Bimala Korana. Super number MAT 5 of 2005.
Kumudar Ranjan Sarkar and versus
Kumudaranjan Savjar. SAOJAL. Savjar. Versus Srimati Bimala Korana. Super, I remember it was the MAT number 5 of 2005.
5 of 2005.
2005. MAT 5 of 2005.
Maybe.
I will provide a hard copy. And another judgment I will provide in respect to, I will provide to this court officer, in respect to that in case of will, court should not see the technicality.
Well,
of
that
the
is
will.
everybody. It is known to Joypal. also.
Yes, it is. No, it is. I don't.
Okay.
Every case should be decided.
So we have to go to, got to take some refreshment. So
Yes.
come back after the 3, at 3. So you have completed. If you have any, so you are coming back after 1 hour. Okay.
Lordship, since the next matter,
Yes.
I have to proceed one funeral of my near relative expired.
Yes.
So this matter may be fixed tomorrow, you know. Other side, now it started already argument.
Yes. So your submission is,
Because
so when
Yeah, fine.
when will you go?
at 2:30, I am going
Okay.
there. It will take one.
The learned counsel next the learned counsel for the respondent
Respondent.
has sought for an accommodation. Stop. This the matter tomorrow. Okay. So whether I shall complete the list and hey, Mr. Chakraborty, no, AKB, please. People, আমরা কি পুরো লিস্ট ডেকে তারপর না বলনা কি করব লিস্ট ডেকে নেমে যাবো নাকি so what is Mr. Lal?
That transfer for that.
Today speaks for that order. Which? Just a minute, 10 call to.
My lordship, I am appealing for the appellant, my lordship.
Who is for your other side?
Mr. K. Sabir, he is hospitalized.
Huh?
He is in hospital.
Hospital?
Yes, you know, it will not be possible for him to.
Has been hospitalized.
Yes, your lord. I got information he is in a hospital. So next
you are
circuit I
appealing
will
for,
pray.
you are appealing for?
I am a proxy on behalf of Mr. K. Sabir, who is the respondent here.
I am for appellant, my lordship. Learned counsel K. Sabir is
Acha.
respondent number 1.
The learned counsel for the respondent number 1 is indisposed of. This the matter when?
Next circuit, your lord. It is not possible for.
And he has been hospitalized, as submitted by the learned counsel for the respondent number. No, you already hold on. Has been hospitalized. Full stop. Stop. Where? Hospitalized. Stop. In view of the matter, the instant proceeding is adjourned. Place the matter before the next slide. Next slide.
Of liability.
Then 11. So how is that? So who is for the other side?
As for the direction, amount of. It's a check of.
No, you bring that certificate from the registry.
This is a
here.
letter addressed to registrar.
Oh,
Was submitted to him.
so how is the receiving?
It's a check now.
Okay, okay. Please take instruction. একটা link to that.
Check now.
The learned counsel for the appellant has submitted one letter dated 28th March 2025 of the Deputy Director within bracket headquarter of the Directorate of Transport addressed to the Register Circuit Bench of the Calcutta High Court, Port Blair, forwarding one check being number 727796 dated 27/3/2025 as per
For an amount of 3,54,000.
okay, for an amount of rupees 3,54,520 as per order dated March 13, 2025. Stop. Learned Register Paradev is requested to submit a report whether the same has been received there is no receiving seal or anything. Whatever you know, whether that has been received and honored. Whether that has been whether that letter along with check has been received by his office. So this matter tomorrow's for him. Please come back tomorrow. Inform the এটা তো করতে হবে এটা করবেন yes anything else so you are appearing for
And for the commissioner, my senior was not in this case. Wherein lastly, the administration was assisting, wherein the issue was pertaining to the court fee.
yes but
The administration was directly where to take instructions from.
yes or is anybody appearing
No one is.
Shatatul Chakra Mr. Chakravarti is appearing
They were supposed to take instructions.
Mr. Chakravarti is not available today
Yes, sir.
so not today then
Yes, sir.
okay
Sorry.
There was some misconception of fact on such facts. Yesterday I said, it's my mistake. But there are series matter where it's my mistake. I take my mistake. So it could not have been done. And I have also checked when the matter was listed again, I checked the records.
so go out of list or something
I can press it. There's an interim claim. My adversary had just told, they will file a position, I can press for an interim.
press for interim order so there is no interim order
This one interim has a.
so affidavit in opposition he wants to file an affidavit in opposition or is an application of writ petition the learned counsel for the respondents you are appearing for all the respondents
Yes, sir, my senior.
or wants to file an affidavit in opposition, stop. Let such affidavit in opposition be filed within 3 weeks from date, stop. Affidavit in reply, if any, be filed 2 weeks thereafter. Place the matter.
Interim order.
Interim order. No. Then I have to hear.
There's an eviction order. It's a second round.
So how is it? Are you ready? Are you ready to argue? So far as this interim
My
order.
senior.
So not today then?
That's not.
Release the matter tomorrow for hearing on the point of interim relief. Huh, okay. Who is your senior?
Miss Babita Das.
Okay. Next.
All the same.
Oh, same thing.
I'm so sorry now. This matter. Because there are two.
You are so busy and you have so much griefs. No problem.
Not educated.
No, I understand, no problem. Okay. Okay. Very fine.